Right, moving on to the next category of useful defence to be aware of, which is reducing the amount payable under the mortgage. And as I've said earlier, there is the power to reduce the interest rate when making a time order. And then if you don't have a regulated mortgage contract, then the court also has a wider power to even rewrite the mortgage under the unfair relationship provisions. But as that's unlikely to apply, I'm not going to consider that in more detail. The two more, well, not common, but probably better chances of knocking out unfair interest or cost provisions are to argue either that they amount to a penalty at common law or they're unenforceable because it's an unfair contract term. But what I'm talking about here are what I'd refer to as secondary rates of interest that apply on default, or cost provisions that apply on default, which in respect of the first, with interest, if it amounts to penalty, is out of all proportion to the lender's legitimate interest. And where you draw the line as to out of all proportion is often, it depends the judge that you get, but it's generally recognised that increasing an interest rate on default by a percentage point or 2 percentage points is unlikely to be a penalty at common law. But you may have a mortgage which increases the interest rate on default to considerably higher than what the general market is paying for interest. And in those circumstances, you might be able to argue that that interest rate is a penalty. The other way of arguing it is under the, if it's an unfair contract term, either under the Unfair Contract Term Regulations 1999 or the Consumer Rights Act 2015, depending on when the mortgage was granted, albeit for our purposes here, it doesn't really matter whether it's under the regs, 99 regs, or the 2015 Act. Again, it's only in respect of secondary rates of interest, and you can't attack what are called core terms. And a core term under a mortgage is that you have to repay the sum that's been loaned within a particular time, over the term of the mortgage, and it would also be the interest rate that's payable. The interest rate that's payable is a core term, but like with penalties, you may have secondary rates of interest, which arise on default, which you could potentially attack as being unfair. Now, whether a term is unfair is if it is contrary to the requirements of good faith and it causes a significant imbalance in the parties' rights and obligations arising under the contract to the detriment of the consumer. Now, in mortgage agreements, it's like pretty much all terms are going to create a significant imbalance in the parties' rights and obligations, which are to the detriment of the consumer, especially terms which require, say, costs to be paid or an increased rate of interest. The case that's set out above in respect of penalties, the MacDC case, also considers the position for unfair contract terms, because there were a variety of cases that went to the Supreme Court and they considered both legal points. And it's whilst it's not impossible, it is hard to show that such a term is not in good faith, because what the Supreme Court noticed is that a term is likely to be in good faith if it is common and used regularly in similar contracts. There's a reason for the term, and despite the shift in the contractual balance in favour of the supplier, the consumer is not left without protection. Now, in more regulated mortgage contracts, provided that the increased rate of interest is largely what the market does, and there will be a reason for the term. It's to prevent or to discourage mortgagors from defaulting on their mortgage. And there will also be protection, because the court retains the right, as I've said previously, to reduce the the rate of interest. So under the section 129, when a time order is being made, so the consumer is not left without protection. So this means that you are unfortunately going to have to be looking at, for either arguing it's a penalty or an unfair contract term, quite considerably high rates of interest that apply on default, or very high costs, which are sort of out of all proportion to being a proper detriment. But those sorts of terms do exist, certainly not being applied by the sort of mainstream brands, the high street banks, but there are mortgages that certainly I'm unhesitatingly argue do not satisfy the requirement of good faith and can be a penalty, but you just need to find them. But it's certainly worth having this in mind. It's also, even if you're it's not such a clear-cut case, it's a good way of buying time by pleading such a defence, and it's a useful negotiating tactic, because obviously certain lenders don't want to have district judges finding that their terms are unfair or are penalties. Moving on to counterclaims, the first one to consider if you have a disabled mortgagor, probably the Equality Act. The case on the slides there, Green and Southern Pacific Mortgages Limited, establishes that the Equality Act applies to the provision of mortgages, and indeed that there is a duty to make reasonable adjustments. But what Green decided is that the duty to make reasonable adjustments does not extend to a requirement to convert a repayment mortgage into an interest-only mortgage. And that's because Ms. Green was able to afford pay the interest, but couldn't pay the capital payments. And she tried to argue that a reasonable adjustment was therefore to convert the mortgage into an interest-only mortgage. But the Court of Appeal said the duty to make reasonable adjustments does not go that far. Therefore, it's hard to see what reasonable adjustments could be made generally beyond perhaps extending the life of the term to a very limited extent. But in practice, in my view, the Equality Act can be of some assistance if it can be shown that it was disproportionate for a claim for possession to be issued against a disabled mortgagor, where you'd otherwise have a Section 15 defence, so the inability to pay is due to the mortgagor's disability. And if you can show that it's temporary and there's sufficient equity in the property so that the security isn't threatened, it's certainly arguable that it would be disproportionate to issue a claim for possession in those circumstances, especially if the mortgagee hasn't bothered to comply with the pre-action protocol or has only paid lip service to it. You may be able to run a Equality Act counterclaim, which, whilst on the Vento scale of damages, you're not likely to be getting, tens and tens of thousands of pounds. You'd probably be looking at something between low thousands of pounds up to £15,000, depending on how bad the mortgagee's conduct was. You never know, that might be sufficient to wipe out the arrears, and would be a really useful addition to arguing that a time order should be made, or maybe that the claim should be adjourned generally. The other counterclaims I just mentioned, first, you're just not going to see that anymore, but I thought, given we were looking at counterclaims, I'll just flag it. But where you may have slightly more joy is where the Financial Conduct Authority's mortgage conduct of business rules, where the mortgagee has breached those rules, they're commonly referred to as MCOB. Then if a loss has been sustained as a result of a breach of those rules, then the FSMA 2000 gives the borrower a claim against the lender. Now, often there is a chapter which is devoted to possession claims, and it largely mirrors what the pre-action protocol says. It's a bit more, slightly more extensive, but essentially, unsurprisingly, lenders are expected to act fairly towards the borrowers, and possession is last resort, etc. But the difficulty is, I say, I can't quite see how, if they breach that provision of MCOB, what loss the borrower is going to suffer, other than perhaps incurring limited legal costs potentially, although I'm not sure that would work in defending such a claim. But probably where you're most likely to have more joy is if the borrower has been missold a mortgage or has otherwise been subjected to unfair practices. So they've essentially been lumbered with a mortgage that they should never have because they could just never afford it. And as a result, they're having to pay increased interest, legal costs, which they should never have had to pay. And that would definitely be a potential counterclaim. Although, again, establishing that, it's easier said than done. It's important just to stress that the breach of MCOB is just a counterclaim. It doesn't render the mortgage unenforceable. And there's a case called Thacker, which establishes that, where a borrower tried to establish that it was a defence to a possession claim. It's not a defence, but it can act as a counterclaim, which, when coupled with the court's powers under the Consumer Credit Act or Section 36, could result in the arrears being reduced or extinguished, and therefore giving the court the jurisdictional basis to suspend a claim, an order for possession, or adjourn a claim for possession. Now, before moving on away from defences, these are the last type of defences I think is important just to consider in a bit more detail, and that's defences for vulnerable borrowers, although not necessarily have to be vulnerable, but it tends to be the sorts of defences that are more likely to arise. And the first that I want to consider is undue influence. And again, perhaps I'm shoehorning this into defences for vulnerable borrowers, because you don't necessarily have to be vulnerable to be the victim of undue influence, although it's probably more likely. But this is one of the best defences for mortgage possession proceedings, and therefore I thought it merited a little more analysis than some of the others, because if this defence is successful, this results in the mortgage being set aside, and unlike a lot of the equitable remedies which result in mortgages being set aside, there is no need for counter restitution. So it essentially means that the mortgage is gone and there's no requirement to repay the capital sum. And moreover, it can also result in the mortgage being set aside even if it isn't the lender who took advantage of the borrower. It can be a third party. And there are two types of undue influence. You have actual and presumed, and when they're not really that different, you have to establish undue influence. And undue influence tends to mean the same thing, but as we'll see, a presumed undue influence is quite useful because you don't have to actually prove that one person has taken unfair advantage of another. You just simply have to point to a particular type of relationship and a transaction that calls for an explanation. And unless the presumption can be rebutted, then you have undue influence. But let's just have a look first at what actual undue influence is. The first is where you have threats or improper pressure, and that's, I mean, in a way, that's like duress rather than undue influence. But the cases do say that it's the first type of actual undue influence. But the more likely scenario is where you have a relationship which exists where one person has a dominating influence over the other, and they take unfair advantage by causing the other to take out a mortgage. So you have to prove two things. One is you've got this type of relationship where one has a dominating influence over the other, and then you have to prove that they have taken unfair advantage by causing the other to take out a mortgage, and that can be difficult without evidential and documentary proof, which doesn't tend to exist when one person has a dominating influence over the other. It tends to be done in person. So the presumed undue influence is really, really useful, and it's far easier to prove. There you have to prove that one party has a measure of influence over the other, and there, as I said, there's a transaction that calls for an explanation. And there are certain types of relationships which are established that it's taken there is a presumption that one party will have a measure of influence, and they are what are set out on the second to last bullet point. You have a parent and child relationship, guardian and ward, solicitor and client, doctor and patient, religious or spiritual advisor and follower, and trustee and beneficiary. So that will always satisfy the first part of that test. For other relationships, you need to prove that such a relationship exists, i.e. one party has a measure of influence over the other. Now, to show that one party has a measure of influence over another, simply pointing to a family relationship is not good enough. You have to show that the borrower placed trust and confidence in the other party in relation to the management of their financial affairs. So the fact you have a husband and wife or two civil partners, that's not enough to establish the relationship. You have to show that one of them essentially is responsible for the family's financial affairs. And that may apply in some instances and it won't in others. The next requirement is you have to show that there's a transaction, in this case it will be a mortgage, that calls for an explanation. And what the case law, this is Ettridge shown on this slide, which is essentially the law for undue influence. You only really need to read one case to get an idea of how it all works. What Ettridge says is a mortgage will call for an explanation if it cannot readily be accounted for by ordinary motives of ordinary persons in that relationship. And quite crucially, the court was at pains to stress that the decision of a spouse, or I didn't say this, but we'd say civil partner now, to stand as security for their other half's debts would not, without something more, call for an explanation. So the fact that someone is willing to stand as security for their partner, it's not, that happens all the time. So you're going to have to show that there was something more in it that was to why this really can't be accounted for. Have to be a particularly unfair mortgage, or there's just no benefit at all for the spouse. And the common example is where there's a failing business in which there really is no point of standing as security because the business is almost certainly going to fail. Even once the presumption is established, it can nonetheless still be rebutted. So even if you have proved that there is a relationship of influence and you've proved that there is a transaction that calls for an explanation, if the bank, as it will be, can prove that the decision to take a mortgage was free from the influence of the third party, then the presumption will be rebutted. But that requires full, free and informed thought. And often what the defendants to a claim for undue influence will say is, the party that took out the mortgage had legal advice, so it must have been with full and free and informed thought. But in a way, taking legal advice and still going ahead with a transaction which calls for an explanation actually shows the measure of the influence that they're under and how that they can't have taken it with full and free and informed thought. Because if they had legal advice which said this is a terrible idea, don't do it, and they still go ahead and do it, if anything, it proves that how powerful the relationship is. So what banks have to do to protect themselves is follow the procedure in Ettridge, because simply being able to point that one of the borrower has taken legal advice is not going to necessarily cut it. What a lender has to do in order to protect their position, therefore, is to follow the procedure set out in Ettridge, because If there is undue influence and the lender has notice of that undue influence and does not take steps to protect its position, then the mortgage can end up being discharged. Now, a lender is deemed to have notice of undue influence, and it's notice of that there might be undue influence. They don't actually have to have notice that there actually is undue influence. They just have to have notice of the potential for undue influence. And what Ettridge establishes is that the 4 circumstances set out on this slide will put a lender on notice that there might be undue influence. And if these circumstances apply, and the lender does not protect its position, and there actually is then undue influence proven, then the mortgage will be set aside. So the 4 scenarios are where a spousal partner stands as surety for their other half's debts. The loan is made in the spousal partner's joint name, but the mortgagee, so the bank, is aware that the loan is in reality being made for the benefit of only one of them. Where the loan is made to a company owned jointly by both the spousal partner, and where a bank is aware of a non-commercial relationship of trust and confidence, and one person agrees to stand as surety for the other's debts. So in those circumstances, the lender is fixed with notice, and unless they protect their position, and there is then a finding of undue influence, the mortgage can be set aside. So what are the steps? They are set out in detail in Ettridge, but essentially the bank must advise the person at risk of undue influence to obtain their own independent legal advice. The bank must then provide that person, the solicitor giving the legal advice, all the relevant information about the mortgage and the debts it's securing, and then obtain written confirmation from the solicitor that has given the mortgagor sufficient advice. That the bank doesn't have to check that the solicitor actually gave, doesn't have to sit in on the meeting to check that the proper advice was given. It can just rely on the written confirmation. And then plainly, if the written confirmation shouldn't have been given because the solicitor hasn't given that advice, then the borrower will have recourse against that solicitor. But for the bank's purposes, they just need the written confirmation. So when looking at a defence of undue influence, that's what you really need to be establishing. If there isn't this written confirmation from the bank, from the solicitor to the bank, then it's definitely in play if you can establish the other requirements of the defence. Now I'm going to look at lack of capacity, because this is certainly a defence that can apply to a vulnerable borrower, where a borrower has probably been taken advantage of, because if they lack capacity, they shouldn't have been taking mortgage out in the first place. But it's important to know the limits of this defence, because whilst on the one hand it may seem like an absolutely cracking defence if the borrower lacked capacity and the mortgage has been granted, it doesn't necessarily get you home. And the defence will apply if the lender is or ought to have been, and that has been said by the Supreme Court probably to mean apparent or suspected. So that's when the person ought to be aware of someone lacks capacity. If their lack of capacity is apparent or suspected, then if that arises, then the mortgage is voidable. So if the mortgagee grants a mortgage to someone without capacity and they genuinely have no awareness of the fact that the borrower lacks capacity, then the mortgage is binding and it's not even voidable. So you have to show that the lender either knows or ought to have known that the mortgagor lacked capacity, and that's obviously going to require medical evidence at the date that the mortgage was granted. Well, obviously you won't necessarily have medical evidence from the date that the mortgage was granted, but the doctor providing the evidence will have to go back and say at the date the mortgage was granted, not only did the borrower lack capacity, but it would have been apparent to anyone who met the borrower. It's then for the borrower to elect that the mortgage is void, and until that's done, the mortgage subsists. And if you have someone that lacks capacity, then obviously it's going to have to be the official solicitor having been appointed, or a deputy perhaps having been appointed, which does that, because a person lacking capacity is not going to be able to elect to treat the mortgage as being void. And one of the problems with this defence as well is that even if you can establish that the mortgage is void, it will still be a requirement for the borrower to give counter restitution, i.e. they'll have to pay the sums that were advanced back, albeit you ought to be able to recover any costs and interest that were paid, because if the mortgage is discharged, then they won't be payable under the mortgage. But there is a requirement to give counter restitution, and so that may be difficult to honour, especially if someone has taken advantage of the person who lacked capacity and has spent the money that's been advanced. If it was just spent on the property, then the likely recourse is to sell the property. May also be possible to bring a counterclaim for breach of MCOB. If a lender is granting mortgages to a person who lacks capacity, that is almost certainly going to be a breach of MCOB, and if that results in other losses to them, then there may be a counterclaim as well. And if not, it will certainly be possible to complain to the Financial Ombudsman. Equality Act, as I sort of alluded to earlier, I think that's going to be difficult to apply as a sort of a knockout blow to a claim for possession, because it's hard to see, in my view anyway, how it would be disproportionate for the lender to recover possession in order to enforce security where there's no other way of recovering some loan. I just cannot see a court saying that it's disproportionate for a lender to seek to recover by taking possession the property in order that it can be sold to recover the security. Therefore, in my view, you're really only going to be able to use it to buy more time where the powers under the Consumer Credit Act do not apply. Say it's not a regulated mortgage contract, it's an exempt agreement, and where the jurisdictional threshold in Section 36 can't be met because the court can't be satisfied that the arrears can be repaid within a reasonable period. It's likely that that's in those circumstances that the Equality Act is going to add value, because for the most part, say that the court's powers under the Consumer Credit Act are going to be sufficient to buy time, which is probably likely to be the proportionate response where a disabled borrower has got into arrears. Now, we've reached the end. There's only one more slide after this, and certainly I've been getting tired, so I hate to think how you're all doing there. And it's been a lot to process, but we have finally reached the end, and can deal with this slide very quickly. In short, it's always important to have in mind that there is a real need for speed after the possession order. As I said before, once the property has been sold, the equity of redemption is lost, and that's it. Game over. There's no coming back from that. Before sale, but after eviction, there are limited options available to a borrower. First is pay the outstanding balance, claim for equity of redemption to satisfy the equity of redemption. As I've said earlier, that's unlikely to apply. So what you're essentially left with is to set aside the possession order and or warrant. There's case law which says that the court's powers under Section 36 end on eviction, so you can't use Section 36 in order to support the setting aside of a possession order or a warrant post eviction. And it's unclear, there's no case law, whether the powers under the consumer credit could be made after eviction. So you're essentially going to have to resort to the classic Section 39, CPR Part 39.3, to show that you would have had a reasonable prospect of success, and or show that the warrant was obtained by oppression, which you're all probably very familiar with. The other thing I would just flag at this stage is if the sale is imminent, it's vitally important not just to apply to set aside the order or the warrant, but also to get an injunction to prevent sale. Because say, for example, the contracts were due to be exchanged at the end of the week, setting aside the possession order or the warrant is going to have absolutely no benefit to you whatsoever. You may be able to get your client in for a couple of days, but if it doesn't stop the sale from happening, then the equity of redemption is going to be lost. So if you fear that the sale is imminent, you need to not just be focusing on setting aside the possession order or the warrant, but also obtaining an injunction. Now, if you're before eviction, so there's a possession order that's been made but hasn't been enforced, then the court still has the powers to suspend the warrant and for a time order to be made. Even there's no authority on that, but that's absolutely clear that those powers still arise. And also where you don't have a regulated mortgage contract or regulated agreement, then the powers under Section 36 still apply, and they apply up until the possession order is executed. So if a possession order has been made but not executed, there's still time, and you can still utilise any of the defences to suspend warrants. If you think that your client has a good defence, but they didn't attend the hearing, then you might want to also apply to set aside the possession order so that you can plead a proper defence. But once the eviction has happened, then the remedies available start to narrow considerably. So that brings us to the end of the webinar. I hope some of it is filtered in. Certainly, I hope that it's giving you an overview of the types of defences that are available and where to look in more detail when you have the time. And if this is going to be an area of law that you practice in regularly, you really are going to have to get the text that I referred to earlier and familiarise yourself with the types of defences that are available and when, because there's just so much here. And whilst hopefully this, as I said, signposted you to where to look, today can really only be no more than an overview. If you do have any questions, I have deliberately put my email at the end of this webinar, and even though it's not live and it's recorded, subject to the questions being asked, if they are about the law, I'm more than happy to respond. It depends how many I get, I suppose, and how busy I am. What I obviously can't do is advise on individual cases. But if there's anything from this talk which you thought was unclear or requires further explanation, I'd be more than happy to field questions via email. But again, apologies in advance if I don't respond timelessly to all, because I may be busy and having other things to do. But I hope there's a bit of assistance. Thank you.
Hello, it's me again, back again for a postscript, I'm afraid, because when editing the webinar, I noticed that the last bullet on slide 11, titled Pre-2016 Regulated Mortgage Contracts, contained an error. The slide had said that the financial limit of £25,000 was dropped in April 2014. It was actually April 2008. I'm not sure why that error made its way into the slides, but I apologise. And the slides accompanying the webinar have been amended to reflect that change. Having watched it back, I also thought, especially as I'm giving this postscript now, that I wanted to just clarify something I said about mortgages granted before October 2004 not generally being regulated mortgage contracts. And while it is very unlikely, I just wanted to make it absolutely clear that it is actually possible for a first or second charge of a dwelling to be a regulated mortgage contract, even if it was granted before October 2004. And I don't think I made that clear enough when giving the webinar originally. It is, though, very unlikely, and that's because to qualify, the sum loan must have been less than £25,000 for mortgages granted after the 1st of May 1998, or £15,000 for mortgages granted between 1985 and 1998. And hence, while a number of mortgages will have been granted for those sums in that time, not very many will have been, and those that still exist are likely to be small in number. But there are probably in certain parts of the country likely to be mortgages that are regulated mortgage contracts, even if they were granted before October 2004.